Okay, tonight we are talking about title issues and specifically regarding real estate investment. But these are some general title issues that you may face and run into, and the more prepared you are, the better. As investors, you're going to come along across distressed properties. And that's a good thing because a distressed property usually means you're going to get it at a discount and make some money on it. However, distressed properties very often have distressed owners, and distressed owners may not always be in the best position to sell you a house, particularly when it comes to transferring title. So those are the things we're going to talk about, some issues and conditions with the sellers, which may inhibit or become an obstacle when actually trying to buy the property from them. So I am now trying to forward the PowerPoint. Oh, there we go. Okay, this is the disclaimers all at the beginning. I'm sure most of you have seen this a million times. Today's presentation materials are copyrighted by my office, so don't steal this. In fact, you don't need to steal it because it'll be available for free on the website anytime you want. So you can always go back and look at it. Thank you for attending today's seminar. Nothing I'm telling you is actually legal information, even though it's a lot of legal advice. But since I am not hired by you for this situation, I'm not providing legal advice to you as an individual for your particular situation. So just remember that this is informational tonight to give you some better knowledge, to be better investors. And if you have specific questions about a specific transaction, always just give the office a phone call. My background, pretty much, there's a lot of you online, but I think pretty much everybody knows me. You can just read through this. I've been an attorney for a very long time. I've been a real estate investor for a very long time, been a real estate agent. As many of you know, my office does title and escrow, which is very important tonight since we're talking about title issues. You don't want to get hung up at title, and so you really do want to choose a title company that understands these issues and real estate investment, the kinds of transactions you are doing, because you don't do traditional retail closings that most title agents do. So make sure your title and escrow officer are very knowledgeable in real estate investment. Just more about me, blah, blah, blah. You know that. It's things my office does, and most of you know all of that as well. Today's agenda. These are the first four are really the title issues that you may run into when buying distressed properties. The fifth one is we added on because yesterday's newsletter was about the new Fannie Mae guidelines on the total number of mortgages you can get in your name. And I put that on here because it's how you title your current properties that will make a difference on how many mortgages count against you. So, somebody asked me a question and asked me how I'm doing today. Thanks, Lyle. I'm doing fabulous. Okay. Death. People die. And very often you will be buying properties from elderly people who might be near death or who have just passed, and you're dealing with the estate and the children of the deceased person, and they're trying to get rid of the property. So this is some things that you really need to know if you're dealing with an estate or someone who might be close to dying or who is incapacitated, maybe in a nursing home. These situations, is you're probably dealing with somebody who's not the titled owner, because the titled owner is either dead or dying. So the first thing you want to look into in the easiest situation is if the person you're dealing with is married to the dying or deceased person, or particularly the deceased person. So they were legally married spouses at the time of death. Generally in Utah, and this doesn't happen all the time, so you do got to be aware of that, but generally most spouses will hold title as co-tenants. And what that means is when one spouse dies, the remaining spouse takes 100% of the property. And so if the spouses did own the property as co-tenants, and you have a death certificate of the one that died and an affidavit of identity. And these are just two documents that I can get you and are pretty easily obtained. You can then take that death certificate and that affidavit into title, and the remaining spouse can actually sell you the house without the deceased spouse there. So that actually works really, really well. But it does have to be co-tenants because, and these four unities, this co-tenancy needs to happen at essentially at the same time. When the husband and wife became co-tenants, it happened in the same instrument. That means that usually on the same warranty deed. It was recorded at the same time, and it's recorded as co-tenants. So sometimes one spouse may own the property, and at a later point in time, maybe quit claim deed or through a tenant in common, put the other spouse on there. If that's the case, then there isn't a co-tenancy, and this is not helpful. And if there's no co-tenancy, then the deceased person still owns that property. You have to go through some of these other avenues to sell the property. So make sure you double check title if you're dealing with a spouse and the deceased spouse, and make sure that it is a true co-tenancy. And you can always call our office. We will search title for you and let you know if that's the case. Okay, so if it's not a co-tenancy situation, maybe the person owned the house outright and now the person is dead. Skipped one, tenants in common. That's the other way to hold property. And in tenants in common, each owner has very specific rights to that property, which pass with them even after death. So their interest is inheritable, which means if there's two people, and you are tenants in common, and one of the persons dies, that person's half or 20% or whatever it is becomes part of the dead person's estate. It does not pass to the remaining owners like in a co-tenancy. And so, again, double check title and see how these people, if there are multiple people, how they took ownership. And if they're tenants in common, you're gonna have to deal with the estate of the dead person. And so that's what the sort of the rest of this is about on death. How to deal with title when the person on title has passed away. First, we're going to talk about is the probate process. This is one process to get title to the property that is owned by a dead person. All wills, so anyone who has a will must be probated. A probate is a court proceeding, and essentially what happens is somebody from the estate, usually a child or possibly a remaining spouse, takes all the information into a court, usually the will, and any other information, and gets a judge to essentially affirm the will or make decisions with the will. Now, a judge does not have to follow the will, and that is a very important point. So if you're dealing with somebody, a child, who is trying to sell their deceased parent's home, and they say, oh, well, here's the will, and in the will, my dad gave me the house. And so you think, okay, great, then I can, I just deal with this. Maybe we'll get through probate. I'm going to put this under contract and start working to get this house. Thinking that the judge is just going to, after probate, transfer the house to the child that you're working with. But there may be other children, there may be disputes, there may be issues about the will, it may be contested. And the judge is given pretty wide latitude in making decisions on what is fair and equitable and what can be proven, and sometimes not follow the will. So do not rely on a will as guaranteed evidence that the person you're dealing with will actually get the rights to the house. Once it does go into probate, you must, my suggestion is just don't even worry too much about it until you get this probate decree. That's a court decree. It is a document. It is signed by the judge. At that point, then you know what is going to happen to the property, because that decree, that court order will say, okay, yes, this property will pass to so-and-so. And the court will also appoint what's called a representative, and sometimes called an executor. And that is the person you want to work with. It may not be the son or daughter that you originally started negotiating with on the deal. The judge can appoint anybody to be the representative. It doesn't have to be the representative named in the will or the person that you've been dealing with. So you must wait until this probate decree is finalized. It is signed by the judge. A representative has been appointed, and it's that representative that can sell you the house. It doesn't mean that the representative is going to get the money. The money may be divided among children. That's another matter. But it's the representative assigned by the court that has the legal authority to sign title documents to transfer the house to you. So that's what you need to do if there's a will. Let's see, letter testamentary, that's also another letter that is issued by the court, called a letter testamentary. It's the final decree of the court. You may want to ask for that and look for limitations in it, because the representative may be limited in his or her powers. So someone may be appointed representative, but they may not have the power to sell you the house. That'd be unlikely, might be a little rare, but you will want to confirm that. So that's if somebody has a will. If somebody doesn't have a will, they're called intestate. And through that, it doesn't go to a probate court, it goes through an administrative court. But for all intents and purposes, it's the same thing. It's still a court process. The children show up, the heirs show up, they bring emails and letters from their parents saying that they were supposed to get this or that. And essentially just goes to a judge to make a determination of what's supposed to happen to the estate. And at the end of this one, you'll get a letter of administration as opposed to a letter testamentary. But again, you're waiting for the final court order that is signed by the judge that appoints an administrator or representative that you can then deal with. And that's the person that needs to be signing your repsies, et cetera, because they will be the ones to sign the title. So if you're working in advance, before the probate or the administrative hearing is done, and you're getting all your contracts signed and getting everything ready, if the person you're working with doesn't become the representative, you're going to have to redo all of those documents. So again, it's up to you whether or not to put the time and effort into dealing with somebody who may or may not be the one that can sign documents at the end of the day. Now, we looked at someone if they have a will or if they died without a will. The third thing that happens, we're going to talk about trust. I know you're thinking, well, what if they have a trust? That's on the next slide. If someone doesn't have a will or has a will that's not probated and 3 years have passed, and I guess it's possible you might find the property that some child found that their parents owned years ago and their parents have been dead forever. If it's been after 3 years, you can go and get an order, a court order, that child can actually sell the house. And what they'll do is they'll just look at the state inheritance law, and because the state statutes define essentially who inherits what if the dead person hasn't given instructions. And the court will just identify the next of kin, and that next of kin can then own and sell you the house. And so you can go to court order and get an inheritance statement, or you can go through a quiet title action, which is a little bit better. The inheritance route only allows a person to sell you the house. It doesn't deal with disputes on title or liens on title. It just says, hey, this is the heir, so the heir can sell the house. If you go through a quiet title action, the court will actually look at all claims on title and settle once and for all who is the true owner. So that is generally, especially if it's been a long time, there may be a lot of people out there that, are claiming rights to this land. So a quiet title action is probably a better route to go. Okay, now hopefully, if we're lucky, um, the deceased had a trust. Uh, a trust is a contractual arrangement whereby the owner of the house puts the property into a trust to hold and distribute upon their death. The trust will name a trustee, and the trustee is the person that you need to be dealing with. So again, the important thing here is, as a kind of a side note, don't ever, ever, ever believe the person you're speaking with. If they say they own the house, or if they say they're the trustee, or if they say they're going to get it in the will, or if they say they're the executor, do not believe them. Trust me, I've seen too many cases with too many clients, and families, and families get in disputes all the time, and children don't talk to each other, and parents don't talk to their kids, and kids don't talk to their parents. So ask for the documentation. Ask for a copy of the will. Ask for a copy of the trust. If it's gone to probate, ask for a copy of the court decree. But the trust, here are some of the issues you need to kind of be aware of. Determining who is the trustee is the most important. Usually the deceased is the original trustee on his trust. That's how most family trusts are written. But once that person dies, the trust will name a successor trustee. And that person is the person you now need to deal with. So you'll need to know who the successor trustee is. If that successor trustee doesn't want the job, or is incapacitated, or isn't around, or maybe the successor trustee has already died. A lot of family trusts will name a spouse as a successor trustee, but the spouse predeceased the maker of the trust, and they didn't edit the trust or amend it because of that, and so the successor trustee is already dead. You need to kind of read through the trust to find out how that next trustee is going to be appointed if one isn't named. And usually in most family trusts, if the successor trustee is dead or gone, the new trustee is usually appointed by a majority vote of the beneficiaries, who are probably the children who are all disputing. And that can become a major hassle if none of them can agree on who's going to be the trustee because they have all their own self-interest. And if that's the case, you may end up in court anyways. There are issues if there are multiple trustees. Some trusts do set up co-trustees. And then you've got two people, and both trustees will need to sign documents unless something in the trust allows one of the trustees to act independently. Sometimes a trustee might be the spouse of the deceased person, but maybe the spouse is now elderly and in a nursing home or has Alzheimer's. And you need to get a ruling of incapacitation on this trustee so that you can go to the next in line or to appoint a new trustee. And incapacitation usually takes the opinion of two doctors. So determining who the trustee is can be an issue. So again, you want to get a copy of the full trust, not just an affidavit of trust, which gives some bullet points about it, but the actual full trust, and you'd want it reviewed by an attorney. If you're dealing with a property that's in a trust and the settlor, that's the grantor or the maker of the trust, maybe he's still alive, but he's incapacitated. That's another issue. And I promise you there will be family disputes. I've got two clients right now that are sitting on properties that they've actually purchased. They purchased from the trustee of the trust, and now other children, other beneficiaries are challenging the transfer by the trustee. They're saying the trustee didn't have the authority, that the trustee took money and didn't give it to the rest of the kids, etc. Most likely, my clients will end up with the property because they have kind of what we call clean hands. They purchased the property not knowing about any of this. They just bought the house from the person who was, on paper, the legal trustee. But it is tied up, and there's not much they can do with the property until the court settles it, and that may take a year or two. So again, get a full copy of the trust, have your attorney. A couple other things about death and titling. Powers of attorney. Remember that a power of attorney is not valid after death. Powers of attorney do work if the person that owns the property is incapacitated, has Alzheimer's, in a coma, etc. If they've done a valid power of attorney to somebody else, that attorney, the named attorney in fact, can sell the property on behalf of the incapacitated person. But if that person dies, that power of attorney becomes null and void. And I've had clients rush to close on something with a power of attorney before the person died, because at that point the power of attorney is null and void. Sleeping deeds. These are deeds that are signed and notarized, but not recorded. So some people, when they get old, would sign a deed, transferring the property over to a child, but not record until after death. You don't see it a lot, but if you do see it, it's a very challengeable situation. You need to proceed with caution. Make sure that your profit on that is going to be worth the possibility of someone coming out of the woodwork and challenging that deed. I will not, in my title office, I will not record a sleeping deed. I won't record a deed that was signed a long time ago, and someone comes to me now and says, "Oh, well, yeah, my dad said, that I was to keep this until after he died, and then I can record it so that I can have the house and sell it to somebody." I won't record it. It's just too challengeable. And there are some things called death deeds, but we don't have them here in Utah, so I will let that go. Okay, so that's death. Any questions on death, actually, before we move on? You can raise your hand or type in a question. I'll try and keep an eye on that. We'll keep going. Okay, divorce. You may be looking at a property that was owned by a legally married couple, and now they're getting a divorce. This is always a super, super, super tricky situation. Always wait for the court order, the divorce decree. Do not rely on what an attorney says. Maybe you're, one of the attorneys for one of the clients. Don't rely on what they say. Just don't rely on anything until there's a divorce decree. It can get really, really ugly, as you well know. So your best bet there is just to sit tight and wait till the final divorce decree. If that divorce decree transfers the title to somebody else, say from the husband to the wife, and you're dealing with the wife, right? She wants to sell it to you, and but she's got to get it from her husband first in the divorce. The divorce decree will be entered. Then with that divorce decree, then you need to get the owning spouse to quit claim it to the wife. And then after it's quit claimed and she now holds legal title, now she can sell it to you. That's the best way to do it, is to get the spouse to transfer the property. If the spouse refuses, you can record the divorce decree if that divorce decree contains a legal description and a statement of who's to own the property. Because it is a court order signed by a judge, and if it contains that legal description, because anything recorded with the county has to have a legal description, and it says who's to get it, that can act as a deed, and that will transfer the property to the spouse who you're dealing with. The issue that kind of comes up, and it's not so much a concern of yours, except might cause you headaches down the road, is maybe one spouse does get the right to sell you the house. So you have the divorce decree, you see that the husband has the rights, you're dealing with the husband, and the husband sells it to you. The divorce decree could read that the proceeds are to split equally between the husband and wife, but then the husband doesn't transfer half the money to a spouse. And now you've got a very angry spouse who may try and tie up the property, may try and put a lien on it, or tie it up to get her rights to it. She's probably not going to win against you as the new owner of the property. Just like in the other case where I told you that my clients bought property and now there's disputes among the siblings that he bought in a trust from a trust. But it could come back behind you and it could tie things up for a little while, or you may have to spend some money to remove that lien or something like that. So you may want to read that divorce decree and work maybe with the couple's attorneys and make sure at closing that the money goes to who it's supposed to go to. That's not your job as the buyer, but to protect yourself from future problems, you may want to confirm that and look into that and make that happen. Okay, bankruptcies. Chapter 11 is a business reorganization. You may not see a lot of those, but if an LLC owns, someone sets up an LLC to own properties and invest in real estate, and then that LLC goes bankrupt, that LLC may file a Chapter 11, which is a business reorganization, and it acts just like Chapter 13, which is an individual reorganization. And in both of those situations, the debtor works with the creditors to adjust amounts owing, interest rates, terms, to get on some kind of plan that the debtor can then meet. Usually all the creditors take some kind of hit. They get 80 cents on the dollar, 50 cents on the dollar, but then they get put on a payment schedule and get paid back at some point. And then a Chapter 7 is a full liquidation, which means the court comes in, takes all of the assets of the borrower and sells it, liquidates it, turns it into cash, and then pays off creditors as best they can. Note here, and this is, we started off with this, remember that distressed properties have distressed owners. If you're getting a really, really good deal on a property, it is possible that that owner has or is about to file for bankruptcy. So do good due diligence. Check in, ask them the right questions. You may want to search the court records, the bankruptcy court records. My office can do that for you. And confirm that they haven't already filed bankruptcy and that they're not planning on filing for bankruptcy. And particularly if they tell you that they are thinking about bankruptcy, that puts you in a very, very, very bad position. Because if you have knowledge that this person was going into bankruptcy or possibly going into bankruptcy, and then you buy the house, and then that person actually does file for bankruptcy, the trustee in bankruptcy can go back a couple of years and look at any transfer of asset that borrower did, including the one to you, and take that property back as a fraudulent transfer. I've got a client who purchased a property, bought it off the MLS. The seller was represented by an agent. My client, the buyer, was represented by an agent. The property was listed on the MLS. The seller was the foreclosing bank. So this property had been foreclosed on. But a previous owner, about 2 owners back, had filed for bankruptcy. And the trustee in bankruptcy wanted to go after any asset that this guy had. And because my client was 2 or 3 people down the chain of title, he was sued. I mean, my client was literally sued. He was a defendant in a bankruptcy action. And the trustee in bankruptcy is arguing to get the property back. Now, he's not going to get it back. My client had, like I said, clean hands. My client didn't know about the bankruptcy. Both sides were represented by real estate agents. It was listed on the MLS. He paid fair market value, and he had no idea who this debtor even was. But it has now been 18 months, and it is still in litigation. Fortunately, the title insurance kicked in, and the title insurance is paying his litigation fee, so it's not costing him anything. And he flipped the house, so he doesn't even own it anymore. But the fact is, he is listed as a defendant in a lawsuit. And when he goes to get a mortgage or something, and someone does a background check, they are going to see his name listed as a defendant in a court action. And so he's going to have to then explain what's going on, and it could be a total hassle. So again, just things to know of what could happen so you can be prepared and be better investors. Once something is in bankruptcy, you can't do it. The owner can't do anything. I had a client, spend a lot of time, weeks, negotiating with a guy to get the property, and the guy was already in bankruptcy. And so there's nothing that can be done. At that point, once bankruptcy is filed, you must work with the trustee in bankruptcy. That's it. That's the only person that can sell the house. Even though the owner is still on title as the titled owner, he can do nothing. And so you need to find out who that trustee is, and work with the trustee. They may want to sell you the house, but that'll give them some cash they could pay out creditors. So that may still work, but you just have to know that you have to work with the trustee in bankruptcy, not the actual owner. Okay. Debts, we won't spend a whole lot of time on debts. These are just a couple kinds of things you may see on title. Liens, you know what a lien is. Mortgage, trust deeds, these are all liens. It's an interest in a property securing a debt. They can be voluntary. These are trust deeds, like a note and deed. They can be involuntary, like a mechanics lien, judgments, county taxes, federal taxes, HOA fees, and even attorneys. So if you don't pay me my attorney's fees, I can put a lien on your property. Go figure, attorneys write the laws. And then there are judicial liens, like a divorce. Perfection just means that these liens have to be essentially recorded. For example, to get a mechanics lien, the contractor needs to apply with the state, get on a list, pay some fees, and then file some more papers that a debt is owed, and then file some more papers, and then they can file a lien on the property. But if they go through that process and then actually file the mechanics lien, then it's considered perfected and it is a lien on the property. Now those are liens. There are other what we call encumbrances on title. These are clouds or things that just sort of cloudy, muck up the waters a little bit. The first is called a notice of interest, or NOI. Many of you know these. I actually use these quite often with my clients. This is just a notice of interest you put on a property. You can do it yourself. You don't need the property owner's permission. But before you go slapping notices of interest on property, you must have some sort of written evidence that created an interest in the property for the debt. So if you loan somebody $10,000, your family member or a neighbor $10,000, it's an unsecured note. You say, hey, they were in trouble, they needed 10 grand for bail because they were drunk driving. So you just loan them $10,000, and they even, let's say they signed a promissory note. They say, yeah, yes, and I owe you $10,000. And then 6 months later, a year later, they still haven't paid you the money back, and you're thinking, well, great, how do I get my $10,000? Well, they own this house, so I'll just go put a notice of interest on this house for the $10,000. And then that way, if I don't get it back at some point when they sell the property, I will get a phone call, and they'll ask me, to remove my notice of interest, and I'm going to say, great, I'll remove the notice of interest, but only until I get my $10,000 back. The problem with that is that promissory note didn't create an interest in the property that you want to put the notice of interest on. And if you put a notice of interest on a property without the proper evidence that you were allowed to do this, the debtor, the person that owes you the money and owns that property, can actually turn around and sue you and get 3 times the cost that it costs them to get you to remove the notice of interest. So if they have to hire a lawyer and force you to remove this notice of interest, and it costs them $3,000 or $4,000 to remove this notice of interest, they can actually get $12,000 to $15,000 out of you. Because in the law, we don't want people clouding title without justification. Otherwise, everybody would go around slapping notices of interest on everybody's property for every single little debt that they ever have. So generally, I do a lot of notice of interest in my joint venture agreements, where one side is putting up the money, but the other side owns title, and they don't want to put both people on title for a reason. Then in the joint venture, I usually say that the party putting up the money retains the right to put a notice of interest on the land, and so something like that. So just kind of be aware of that. But if you're trying to clear title, then a notice of interest can prevent the sale of property until that is removed. A lease pendens, that's just a notice on the property that the owner is subject to a lawsuit somehow. This is usually maybe over boundary lines or encroachments, or maybe it's a quiet title action, or even a joint venture agreement that's gone awry. So just aware of some debts. And the final thing tonight, titling and mortgages. As most of you know, Fannie Mae's long had limits on the number of mortgages that a person can get that they would insure. It was 10 for a long time. Then during the crash, it went down to 4, but it's back up to 10. And you can get 10 mortgages in your name. And for a long time, that was great. You could, as long as the only mortgages that counted were mortgages where you were the named borrower on the mortgage. So if you had 10 mortgages in your name, that's all you could get. If you had 5 mortgages in your name, you could go get 5 more. They recently, I think it was February or March of this year, they changed the rules. And so they now, in counting those 10 properties, those 10 mortgages, they will include all the mortgages where you're the named borrower. It will include all the mortgages on properties where you have an ownership interest. So let's say you and your spouse have an LLC. It owns 10 properties. 5 are mortgaged in the husband's name, 5 are mortgaged in the spouse's name. So each person only has 5 mortgages. But the husband and wife own the LLC that owns all 10 properties. So in counting mortgages, the husband and the wife each have 10 properties because the husband has ownership in the 5 properties that have a mortgage on them. So if you own any property in some fashion, whether you're on title, whether you own it through an LLC, a corporation, a trust, a family limited partnership, but if you have ownership in a property that has a mortgage on it, that mortgage, even though it's not in your name, counts towards your 10 properties. So that suddenly dramatically increases the number of mortgages a person has. You may be in a partnership. You may have done a credit partner, and you have an LLC, and you and your credit partner on the house. Your credit partner got the loan, and so he has the mortgage. You provided money for the rehab, and now you guys own this rental property together. That mortgage property counts towards your 10 mortgages. So you need to be aware of that if you're looking at building a portfolio of rental properties and maxing out on your mortgages. A couple of the notes we wanted to talk about tonight is just that for asset protection purposes, we like multi-member LLCs and partnerships, right? We like having husbands and wives on an LLC or working with partners because the more members you have in that LLC, the greater protection you have. So it's great for asset protection. However, for mortgage qualification, a lot of my clients are now splitting their LLCs, creating one LLC for the husband's mortgaged properties, and another LLC owned by the wife for the wife's mortgaged properties. And for a short time period, they're just going to have these single member LLCs until they max out on their 10 mortgages, and then they can recombine them and get the asset protection. So it's a decision you need to make. Is what's more important, asset protection or qualifying for mortgages? So that's just something to sort of be aware of, and there's no sign that rule is going to change, and my guess is it's not going to change. So Be aware of that. Make sure you have a good discussion with your qualified mortgage lender, your mortgage broker, and make sure you talk with your attorney and discuss your particular situation and what's best for you, what your goals are, and how best to proceed to get the most protection you can in your real estate investment business, but at the same time be able to get mortgages and increase your business. So that is all I have for tonight. So I will just now leave it open for questions. So if anyone has a question, they can. Christine has a question. Okay, Christine, I'm going to unmute you. So Christine, you can now go ahead and ask your question if you have a microphone. Do you have a microphone, Christine? Maybe you don't have a microphone. You can type your question as well. That might be an easier way to do it. I'll go ahead and mute you again. Does anybody else have a question? Wow, I must have done a very, very good job of explaining everything. You can see, you can continue to raise your hand. Looks like Lyle, no, we'll clear that. You can type a question. Remember, always contact our office. Feel free to give us a call, send us an email, and ask us any questions about stuff we talked about tonight or any questions you may have regarding your business. We're always here to help. Yeah, so I will, Christine Pitts is going to email the question. So Christine, I will answer your question through email, and I will maybe include that on the next time we do this presentation. So anyways, for the rest of you, have a great night. And as always, just let us know if there's anything we can do for you. Thanks, and that concludes tonight's webinar.